Hi, this is Dana Miller for Education 631 at Liberty University, Discussion Board 6, Topic 1. I am one of the many educators who has used copyrighted material in the classroom, assuming it fell under the auspices of fair use. I am turning 50 this week and have just learned this is not the case. Fair use does not mean fair game. Section 107 does not grant educators wholesale permission to use copyrighted materials simply because they work in nonprofit educational institutions, Simonson Text 2012. Fair use is defined by Congress by 4 criteria concerning the purpose and character of the use, the nature of the work being done, the percentage of original work that is used, and the effect reproduction has on the market value of copyrighted materials, Simonson 2012. The text suggests at least 3 of the conditions be met, with 4 being the desired expectation. Papadopoulou 2010 cites the need for a more comprehensive definition of teaching as well, especially as it pertains to the burgeoning field of e-learning. The Digital Millennium Copyright Act, effective in 2000, is an update of federal law that targets copyright infringement on the internet. This piece of legislation protects both the intellectual property owner and the Internet Service Provider, or ISP, through the use of encryption and filtering software, password protection, and liability protection for the ISP. Libraries and education institutions can circumvent some of these protections only when libraries are open to the public. As such, it applies most likely to higher education settings and not in K-12 settings, Hawken and Russo 2008. Under IDEA, students with disabilities are allowed wider access to otherwise protected works. Now that I know what I know, change will come in the examination of the 4 principles of fair use before accessing and using copyrighted materials in school. On internet sites, I'll check for school acceptable use policies and permissions and plan accordingly.